There we go. All right. Good afternoon, and welcome to the second meeting of the Civilian Review Board. We will be meeting today from 2 until 5. We're supposed to have 2 guests with us today, and I see one is here, and he gets to start. So I would like our Mayor Andy Ginther, to come to the podium.
Good afternoon. Thank you, Chair Jackson, and all the members of the board. Appreciate you making just a few minutes for me to share mostly a message of thanks to you and to your colleagues for your commitment to this process, this effort, and our overall change and reform efforts. Devoting your time and energy to helping us restore trust between our community and the police. And for far too long, police here and in cities across the country have operated without independent oversight. Last November, our residents voted overwhelmingly in favor of accountability, transparency, oversight, and reform. That's why we're here today. Your work will hold officers who've committed wrongdoing accountable for their actions on behalf of the community. The creation of this board joins other significant efforts we've made in a relatively short period of time, including changes to our use of force policy, independent investigations into deadly use of force, new immersive community-based training for our recruits, enhancements to our city's body-worn camera program. And as you discussed at your first meeting, we negotiated historic changes to the FOP contract that will benefit the public and our officers. We're grateful this effort will benefit from the support of our outstanding new leaders in public safety, including Chief Elaine Bryant and Robert Clark, who will formally begin his role as Director of Public Safety later this month. Collaboration is central to our work, no matter the initiative, no matter the challenge we must overcome. We've made tremendous strides toward realizing a 21st century community policing model, but there is still so much more work to be done, and we'll do it together. Thank you again for your service to this community. You're doing and going the extra mile to make Columbus safer and more just for everyone, and I look forward to achieving even more progress together. I was able to greet everybody individually and personally besides Brooke and Kyle, but I want to extend my personal thanks to you for your service in this important work. And to Chair Jackson, thank you for helping to lead this important reform and community-wide effort together. Appreciate you.
Thank you. And I see that second guest joined us.
Thank you, Madam Chair, and thank you to the Commission for allowing me to join. To our Mayor, thank you for your partnership and your leadership to get us to where we are today. I'll be extremely brief. It's one, just to say thank you for stepping up to serve in a challenging time when our residents are looking to you for your leadership, for your guidance, and for the work that you will do over the next months, but really over the next several years to the staff that is supporting this commission. I'm very grateful for you as well. The one thing that I have told some of the folks that I've been on this commission is that you guys are the first, which means that you set the precedent for what this thing becomes. You guys set the standards. You guys set the professionalism. You guys set the guidance, and for every other person who will sit in the seats that you have now. And so that comes with a lot of responsibility, But you know what it also comes with? It comes with a lot of opportunity as well. And so, yeah, we did some work, the administration, City Council, to do a rough outline. And then, yes, the citizens of the Citizens Advisory Group did some more work to shade in a little bit more what this thing is. And yes, the the residents of Columbus, did a little bit more work in advancing this and improving this. But now the ball is in your court, each and every one of you. And so Godspeed. We're right here beside you. To the mayor's point, you guys have some amazing partners now. To be that the chief of police, Elaine Bryant, who is doing the hard work of regaining that trust and building that trust in the community. To our new safety director, there are partners now that will assist along the way. But we look forward to being your other partner as well. And so I am grateful for each and every one of you. Thank you so much for your leadership. Thank you for your time. Thank you for this commitment, because I know, I was going to make a joke, but I know these are, you are not being paid. You are doing this without compensation. And I guess that should be recognized and appreciated by the voters and by our community. You guys are literally donating your time to an issue that will at times put you guys in the middle of a lot of focus, a lot of attention, a lot of time, and sometimes even heartache. And so on behalf of a grateful Columbus, thank you so much.
On behalf of the board, again, we say thank you to Mayor Ginther and to Council President Harden for coming in. And I appreciate the fact that you took time out of your schedules to come and to say thank you. I felt that was really important for the board, so thank you. We will now, before we actually move to the agenda, both the mayor and Council President Harden reference our new public safety director, Robert Clark. And he certainly will be invited to come to one of our meetings. But I want to share with you that I had a conversation that lasted probably 30 to 40 minutes. I was personally very, very, very impressed with him. The mayor asked me, he says, how did the conversation go? And I used one word to describe it. It was rich. He is coming to us with much experience, and so I am looking forward to meeting him, and I will speak on behalf of the board to say we are looking forward to working with him, as well as working, of course, with Chief Bright. So now getting to our agenda of the day. Let me first note in terms of attendance today that all of our board members are here except for Dr. Chanel Jones, who has an excused absence. She is traveling abroad. And then unfortunately, I have to share some news with the members of the board. We have received, or I have received, a resignation from the board. And even though our bylaws have not been approved yet, I'm trying to follow those bylaws as I do the work. And so the bylaws provide that if a board member is to resign, they should notify the chair of the board in writing. And so I have before me the resignation of Randall Sistrunk, and I will read it to you. So it's written to me, from Randall, subject resignation. Good afternoon. This letter serves as my official notice of resignation from the Civilian Review Board. I understand the significance of the Civilian Review Board as well as the expectation of its members. Due to an increase in professional and family obligations, I will not be in a position to dedicate the time needed to fulfill the board obligations. I would be doing the community a disservice by remaining on the board while knowing that I do not have the time needed to be fully dedicated to the work at hand. While I am disappointed that I'm no longer able to serve in this community, I am humbled to have been appointed and would like to thank you for the opportunity to serve. I apologize for any inconvenience that my resignation may cause. Respectfully, Randall Sistrunk. I did have the opportunity to have the conversation with Randall, and I completely understand his reasons in terms of just not having the time. And as you've read the bylaws, you will see that we really will have, as I was talking with Pastor Nathan earlier, we have a lot of training to go through and a lot of other work maybe in the community, so I certainly understand. So the bylaws provide that our administrative assistant, that will be Colleen, will deliver this to the mayor's office. The mayor, of course, then has the responsibility of appointing another person to the board. So hopefully that will occur before our October meeting. So I wanted to share that with you. The next item on the agenda is the approval of the minutes from the September meeting. Can I get a motion from a board members to approve?
Second.
So from Pastor Nathan, the motion, and the second for Mr. Fluharty. Are there any questions or concerns before I call for the vote? Hearing none, all those in favor of approving the minutes, please raise your hand. I believe that's unanimous. The minutes are approved. Thank you. Something else that's not on the agenda. In an email that you received from Colleen, she referenced the need for board members to be fingerprinted. The administration has decided that that's going to be a part of the process moving forward. And so there is an opportunity for you to go today. I think I was told that it takes about 15 minutes. You'd need to leave this building and go to the building, next door. I'm going to leave that up to you if you actually want to get it done today. If you don't get it done today, then you will need to make an appointment to come down and to have that done. I believe that Richard Blunt would be responsible for helping you get, no? Oh, I'm sorry. And Amy, I apologize because I didn't know it was you behind that mask.
They can call me directly or email me at @agalong, and I'll get them scheduled.
Okay.
We'll
But
make
it-
it work for them. Right now, it's till 6 o'clock tonight, if it makes it easier for people to go a little bit later, or any time during the day. We're in from 8 to 5 normally, but if we need to do it later, we'll be there.
Okay, thank you. And if you could send to the board members, again, her phone number and her email address, so they will have that readily at hand. This is early in the meeting to share this, but I want to make sure that you are aware, and it puts a burden back on Colleen. The November board meeting needs to be moved. I'm not available either that Tuesday or Wednesday. So Colleen, you'll need to do another doodle poll, but of course, we will need a meeting. And now, getting us back to the printed agenda. Yes,
There was a meeting that I saw on September 22nd? Or is there another one in September?
no, this board only met once. Now, I sometimes will meet with individuals that I call the internal team, but there was not an official
It was
meeting.
on one of the, on one of the schedules, is what I was,
Okay, but no, there wasn't a meeting.
it's an upcoming meeting.
Was that a result for the training or?
I'm going to talk about the training. I'll just share this with you now. We had issues getting the training scheduled. 11 folks, 11 different schedules, very challenging. So I'm actually going to have one suggestion later in the meeting. I'll go get to that, but that's what it could have been. Okay. We will now hear from the Chief Counsel of the City Attorney's Office, Laura Baker Moorish. Laura has, quite frankly, the bulk of the agenda today. She is going to first share a discussion over all of the ordinance, and then there'll be a review of the proposed bylaws. Now, I know, Ms. Baker Moorish, that we had talked about the fact that we probably wouldn't be voting on the bylaws today. But if we find ourselves in a situation where there's no real change as a result of questions from the board, would we be able to go forward with a vote today, or must it be moved to October?
Is this on? It is, excellent. My recommendation is that we might delay it until October.
Okay.
Just so we can make sure that we finalize all of the language in any particular section, and so that everybody has an understanding of the various pieces. But certainly, if there's consensus that's reached on any particular item, we can note that, and then make sure that everyone has an opportunity to then review it in whole before the entirety of the bylaws are voted on in October.
Okay, thank you.
Thank you. I want to thank the board for the opportunity to be able to present today. I do hope that you've had an opportunity to see some of the materials that were sent out prior to the meeting, documenting the code I'm going to go over, the city charter, and the bylaws. I know it's the most exciting meeting that there could possibly be. But I do want to emphasize it's a very important meeting, because in order for the board to be able to do the things that the board has been obligated to do pursuant to charter and statute, the board must first organize itself as a board. Each one of you has agreed to serve, and that's fantastic. This meeting is about getting to become a board as a whole. And so some of the things I'm going to be emphasizing today as I talk about the charter or I talk about the city code is with an idea that they are going to then manifest themselves in the bylaw draft that I circulated. And I do want to make it clear that that is just a draft. It's my job to try and steward the board towards bylaws that make sense and that address all of the various needs that the board might have, but I am not on the board. These are simply ideas based upon other boards and commissions that act and have acted throughout the city of Columbus over the years. And so I've provided them to provide a framework because it's a lot easier than starting with a blank sheet of paper. Some of the bylaw recommendations come directly from the charter and from the city code, which is why it's important to do this review. Other things in there come more from the general operational nature of boards and commissions. And so there are standard practices regarding what's a quorum and what do you need to do to vote and those sorts of things. So it's going to be a combination of those two things. I will say as we move forward with discussing the charter and the Columbus City codes, to also keep in mind that bylaws are distinguished in the city code from rules and regulations. So as a board, you have the authority to enact both, and you're actually obligated by city code to enact both, but they do serve separate purposes. The purposes of the bylaws are to organize yourself. How is the board going to function? How is the board going to move motions forward? What constitutes a member? What happens if somebody doesn't attend? Those kinds of things. Rules and regulations, think about as being more outward facing. Rules and regulations are the requirements that the board is going to place upon other entities that interact with the board. So think, as we think moving forward about board review of particular investigations or board review of city policies, rules and regulations will be the things that this board creates to address those things. How will a hearing be conducted? What's the timing of it? How will something be filed? How will a citizen file a complaint? Or all the kinds of things that the board would address in rules and regulations. But before you get there, you first have to think about how you operate as a board, and so that's going to be my focus today. So Kate is going to advance the slides for me because I don't have a clicker over here. So Kate, if you could go to the first slide. All right, so this is the city charter provision, which you've probably been exposed to a couple times since being on the board. It's Section 215, the Civilian Police Review Board is created in the city charter. For those of you who I didn't have the opportunity to speak on about this before as part of the advisory group, I'll just refresh everybody's memory that the city charter serves the role of basically as the city's constitution. It's supposed to be the framework for government for the city. It's supposed to paint things in broad strokes, and it's supposed to design, it's designed to differentiate and to delegate powers and authorities among various aspects of city government. So it is the foundational document for the Civilian Police Review Board, but it's light on specific details in terms of how you operate. Relevant to what we're talking about here today, you'll see that the first paragraph just generally talks about how you got here. It shall be comprised of an odd number of members. Members shall be reflective of a diverse community within the city. Talks about what that diversity should consist of. And then it talks about funding in the second paragraph, which is very important, of course, but not important necessarily to creating a bylaw. But within the Civilian Police Review Board, Section 215, one thing that we do need to think about is a majority of whom shall constitute a quorum. You're going to see as we go on and start talking about the bylaws that one of the first decisions that the board needs to make is, and this is actually an appropriate time to think about it, right now you are a 10-member board. There are 11 seats, but we've had a resignation. So when we're talking about a quorum, do we feel that a quorum is a majority of the seats on the board or a majority of individuals who are appointed to the board? So that's one of the questions we're going to have to address as we get to the bylaws. Next slide, please. So now the city code, section 235.01A. As I said, the charter establishes the framework. The city code fills in the details. City code section 235.01 talks about the Civilian Review Board as a board and talks about all the various obligations that both this board as the initial board has, but also that all members of the Civilian Police Review Board would have. So again, the first paragraph talks about generally how you came to be appointed. You can see now it specifies that there are 11 of you, not just that there's an odd number. And it also talks about other considerations that the council and the mayor might take, other items that the council and the mayor might take into consideration in appointing members of the board. The second paragraph, again, talks about your terms. And you'll notice that your terms, because you're members of the initial board, are slightly different than terms will be for subsequent members of the board. Because there was a desire not to have the entire board be replaced every 3 years, we wanted to have the ability to have staggered terms so that there is both the benefit of experience, but also the benefit of new members. As a result, in order to effectuate that desired result, the first members of the board, the initial board, in order to stagger them, had to have staggered terms as well. So some of you are serving 3-year terms, and some of you are serving 2-year terms. Going forward, everyone will serve 3-year terms. Members may serve more than 1 term, but may not serve more than 2 terms consecutively. And members shall hold their seat on the board until their successors are chosen, qualified, and installed. There's also, and this is the hard part, I can see it over here, here we go. The mayor shall appoint one of the board members to serve as the chairperson whose role it will be to preside over the meetings. So what you'll also find, because the initial board, because your first job is to create yourself as a board, the chairperson, Jackson, was appointed by the mayor, but you'll see that in subsequent iterations of the board, actually the board will choose its chairperson going forward. So again, it's really important to establish in the bylaws how that's going to occur. Next slide, please. Prior to being presented to City Council for approval, all potential board members or appointees shall execute a signed release and submit to a full background check as a condition of their employment. Notice that's for new members going forward, but there's a provision in the code specifically addressing initial board members, because of course that didn't exist yet. You shall, prior to beginning your duties as a condition of your continued appointment to the board, be subject to the full background check. So again, thinking about beginning your duties are going to be spelled out a little later in the city code. That involves hearing investigations, that involves doing the review. So once again, we need to get ourselves put together as a board so that you can move on into your duties, and part of that is going to be doing the background check and the training, which will be next. Next slide. So the initial board, in consultation with the city attorney or designee, which would be Robert and I at this time, shall develop standards of professional conduct, policies pertaining to board membership, and a comprehensive training program. So these 3 things, standards of professional conduct, policies pertaining to board membership, comprehensive training program, are the kinds of things that need to be in the bylaws for the Civilian Police Review Board. And you'll see that within the draft bylaws that these are addressed in various areas, but they, of course, are open to being filled in by members of the board. Upon appointment, but prior to beginning their duties, each newly appointed member shall be required to complete this basic course of training. And then the code specifically spells out what that course of training shall include. It can include more, but it must include at least instruction in police tactics, ride-alongs with patrol officers, seminars on relevant constitutional and criminal law, instructions in de-escalation techniques, and training in diversity, inclusion, cultural competency, and implicit bias. So you see from the draft bylaws, we've created a space for where the board can develop policies pertaining to that comprehensive training program. And in accordance with the city code provision, the city attorney's office has provided guidance for what kinds of programs would meet the definitions of those required components of that training program. Again, you can add more if you feel it's appropriate to the work of the board, but those are the ones that are required by statute. Members of the initial board shall be required to attend and complete this comprehensive training, but again, you can't do that in the beginning because it hasn't been crafted yet. So instead, for the initial board, it has to be upon completion of your initial term or upon reappointment if you are to be reappointed, if it's not practicable to have done it prior to that. In terms of it not practicable, we just wanted to make sure that there was enough time to make sure that the comprehensive training program is what you needed it to be before individuals had to complete all of it. And so we wanted to make sure the initial board had time to do that. And since some of you are in 2-year terms rather than 3-year terms, we want to make sure that it was able to be done. Next slide, please. D, the board shall develop rules for recommending to the mayor the removal of one of its members for cause. So once again, the city charter, and we're going to get to that in a second, indicates, and then the city code spells out in more definitive terms, conditions under which a board member may be removed. This is not a voluntary resignation situation, but this is where actively there's a seeking to remove somebody from the board. Those conditions are inefficiency, neglect of duty, which would include failure to attend meetings or complete mandatory training, or malfeasance in office. And one more note on complete mandatory training. Unlike the other provisions that are provided for here as being for cause removals, completion of mandatory training is actually a condition of appointment. So that one would be an automatic disqualifier, whereas the rest depend upon the facts and circumstances and a vote of the board. Next slide, please. Within 60 days after the effective date of the ordinance, which was July 13th, 2021, the board shall meet, you've done that, and organize under the leadership of an appointed chairperson and elect a vice chairperson. So that will be one of the next duties of the board moving forward. Again, the bylaws spell out what the vice chairperson does, and so it's important that the bylaws establish what that role will be so that when you vote someone into that position, you have an understanding of what's expected of them. The board shall annually elect from its membership a chairperson and a vice chairperson, and again, that's beyond the initial board. As the board has been operationalized, then it's going to be the board that selects their chair and vice chair going forward from there. Next slide. The board shall adopt bylaws. See, I told you we're going to get to that. The board shall adopt bylaws to govern the conduct of its business, which shall include provisions for regular or special meetings, voting procedures, amendment of its bylaws or rules, minutes of meetings, the formation of committees, or any other procedural matter the board deems necessary. So you'll see each one of these is in the draft bylaws that you've been provided, but again, there are lots of decisions to be made about what specific provisions you'd like, but all of those need to be addressed in some way, shape, or form. We need to have a rule for those things going forward. Where the bylaws are silent, Robert's Rules of Order would be consulted. So again, that goes to whether or not the board wants to be a more formal level of board. You can really get into the parliamentary procedure. But to the extent that if you'd like instead to have a less formality, then by having bylaws that address a number of common circumstances, then you would only look to Robert's Rules in the event that there was a dispute about how to deal with something that's before the board that wasn't addressed in the bylaws. So again, that allows for the board to develop its own sense of how formal you want to be and how much you want to adhere to those processes. Next slide. The board has the authority to promulgate rules and regulations. Again, distinct from bylaws. Bylaws are about how you operate. Rules and regulations are more outward-facing about how the board interacts with other entities. Those rules and regulations are in accordance with another provision of the city code that spells out, generally speaking, that boards such as yourselves have the authority to adopt such rules and regulations in order to carry out your duties. So as we move through the sections of the city code, you'll see there's a specific provision that talks about what the duties of the board are. Rules and regulations are designed to help and assist you in carrying out those duties. The board and the Inspector General shall develop the procedures necessary for the board to carry out its duties. And again, that's because there is that interlacing of the obligations and duties of the Department of the Inspector General with the Civilian Police Review Board. So you're going to see how important it is for the board as one of the things it needs to do once it's established itself is to find that Inspector General. Because a lot of these rules and regulations that the board might be considering drafting for how to interact with the Inspector General are going to require that level of work with the Inspector General to get those things done. Next. Board shall meet at such times as may be necessary to carry out its business. At least one meeting shall be conducted each quarter. You can certainly meet more often than that, but the statutory requirement is at least once a quarter. Right now, because we have a lot of foundational work to get done, monthly meetings make sense, maybe even more often. But once the board starts working on its duties for hearings and things along those lines, it's going to depend upon the flow of the work that's coming to you. But you at least must meet once a quarter. All meetings shall be public meetings in accordance with the general laws of the state of Ohio. We discussed that last meeting and what that requires. And meeting minutes and records shall be maintained in accordance with the state law regarding public records. Again, we addressed that a little bit last meeting about public records and open meetings. Next, please. All right, so that ends the first section. I'm going to take a pause if the chair wants to have any opportunity, or if you want me to go forward, or what makes most sense?
I would ask of the board members at this time, do you have any questions on the presentation so far? Then if no, please continue.
All right. So moving on to Section 216, Powers and Duties. As I've mentioned a couple times already, this section is going to spell out what the board is here to do. There are a few things that we need to be cognizant of at this point in time in drafting the bylaws and making sure that they are going to address some of these things going forward, but a lot of them are going to end up being rules and regulations that the board votes on at another point in time. I'm not going to read all of this, but generally the top part talks about that the board shall receive, initiate, cause investigation, and recommend resolution of complaints filed with it or initiated by the board. This is going to be the lion's share of the board's work. This is something that would be spelled out in rules and regulations in terms of the timing, the process by which that's going to occur. And you're going to see that you're going to need an up and running Inspector General's office to do some of the administrative work of receiving complaints and processing complaints and investigating complaints and moving them forward. Ultimately, it's going to be how the Inspector General receives that information, does their work and brings it back to you. That's all going to need to be addressed in rules and regulations. How much time does the Inspector General's office have? What kind of information do you want to see before it gets brought back before the board? How much interaction with those reports do you want to have? Do you want to have status updates all the time, or do you want to wait until an investigation is complete? In other words, there are lots of decisions that need to be made, but those would be in rules and regulations that come out of this board. Down at the bottom, subject to the approval of council, shall provide rules providing for the procedure of the board and the review of complaints filed with it. So once again, that links back into the rules and regulations I was talking about. What's the procedure by which somebody could contest a particular recommendation as to discipline or as to whether or not they were in violation, as an example. Next slide, please. So you'll see that the provisions of the city code addressing the board's duties are likewise more broadly spelled out because it is anticipated that the work of the board itself will be largely driven by the rules and regulations that are generated by the board. So the city code section is going to be a little bit more granular than the charter, in the sense it's going to provide some specifics as to what kinds of things the board does. But generally speaking, it's within the board's authority to decide how best to do those things. And when you decide how best to do them, then the rules and regulations will reflect that decision. So broad statements. Number one, to receive, initiate, review. This is almost directly the same thing you just saw in the charter. Number two, to direct the Inspector General to review and provide a report for review investigations conducted by the Division of Police Internal Affairs Bureau for fairness and accuracy, and if warranted, recommend changes to division policies and procedures based upon said review. Three, to make recommendations on resolutions of complaints, if warranted, to the Chief of Police and/or the Director of Public Safety regarding matters reviewed by the board. So again, number one is how you're receiving things. Number two is how you're directing the IG, what to do with those things that you have received. Number three is how the board makes recommendations to individuals who are supervising police officers regarding how they, officers, if warranted, should or should not be disciplined. Next slide, please. Number four, similar to number three, this make recommendations on discipline if warranted to the Chief of Police or Director of Public Safety regarding the outcome of all investigations that were reviewed by the board. 5, to evaluate and identify complaint patterns, make recommendations to reduce complaints based upon said evaluation. That's more of an administrative role for the board. You're looking at patterns rather than just any one particular investigation. 6, to review and make recommendations regarding Division of Police policies and procedures. Based upon your observance of those patterns that might come out of the recommendations and complaints, you'd be in a position to make recommendations regarding Division of Police policies to address the concerns that you might observe. 7, to perform such other duties as are not inconsistent with the provisions of this charter, this chapter. That is a blanket provision that's in most board and commission provisions, to be honest. And that's in case something comes up as we go forward and we realize, hey, this is something that really the Civilian Police Review Board should be looking at. Then council would have the authority to pass another ordinance, either expanding your duties or specifically allocating that duty or delegating that duty, to the Civilian Police Review Board. Next slide, please. The Civilian Police Review Board also has an annual report obligation to City Council, so that's something you might want to consider, even in part of your bylaws as well. How is that annual report going to be generated? What is it going to contain? The statute requires some things in particular: disposition of complaints, outcome of investigations, as well as the board's actions and recommendations, which may include division operations, discipline, trends and patterns, et cetera. So basically, this is council wanting to hear back from the board. What are your findings? What are you seeing? What's your volume like? So that they have a sense for whether or not they need to provide additional support to the board, if there are any statutory changes they need to make, if there are any appropriations that would be appropriate to address issues and concerns. And so there's also going to be a question about what that annual report is going to look like and what story do you want to tell. Next slide, please. All right, that ends that next session. Chair Jackson, did you want to take time for questions at this point or moving on?
Are there any questions on what has just been covered? Then let's move on.
Moving on. All right, so section 217, we're back to the city charter. This once again broadly states what the role of the Inspector General will be. And I know that the questions have been asked about what is the Inspector General's role versus the Civilian Police Review Board's role. And kind of think about it the way that you have executive directors who head up a department and report to a board where that board is guiding their work. So there are a lot of different ways that boards and departments can work with one another. In some instances, boards serve as almost a quasi-adjudicatory function for the department. But the way that this is set up is that it's more of a collaborative relationship between the Department of the Inspector General, who's going to basically do the on-the-ground work, the investigatory work, the administrative aspect, and then the Civilian Police Review Board is the guiding body. You may hear allegations for coming out of investigations. You're going to be reviewing all of them for recommendations. You're going to be guiding the Inspector General on what kinds of things you need to be seeing or that you are concerned with. But the actual day-to-day work of the department's going to be within the Office of the Inspector General and the employees that are there. The Inspector General shall be appointed by a 2/3 vote of this board. So you have an incredible amount of authority here to make that appointment with the confirmation of the mayor's office and to assure that the individual who holds the position of the director of the department, which is the Inspector General themselves, excuse me, is independent from the Department of Public Safety and instead shall serve under the guidance of you as a board. So that's going to be one of the next basic steps. So again, development of bylaws creates the board. Moving on to rules and regulations creates processes. Hiring of the Inspector General, essential in order to create those processes that are going to form those rules and regulations. And then once that's done, the work, the duties of the board and the duties of the Inspector General can begin in earnest. Next slide, please. Code sections relating to the Office of the Inspector General. They may be reappointed for not more than one additional 5-year term. They're going to serve a 5-year term in the unclassified service. That's, again, to give them a little bit of independence. Once they are selected by a 2/3 vote of the full board, they can be removed at any time for, once again, inefficiency, neglect of duty, malfeasance in office. So it's designed to have, as I said, a little bit of independence from the Department of Public Safety by giving the Office of the Inspector General that report directly to Civilian Police Review Board and that 5-year term. Next slide, please. Inspector General shall have professional experience in the investigation of allegations of misconduct and shall conduct the duties of the Inspector General in a fair and impartial manner. Again, that's something to be considered as you start doing your search for who is going to fill that position. There are some statutory obligations, but you might also want, as a board, to think about what other criteria you have for making that election and making that decision. Prior to being presented to the mayor for confirmation, a candidate for the position shall execute a signed release and submit to the background check. Again, that's similar to board member requirements. And it's also a condition of appointment. Next slide. Duties. So once again, within the city code, the first provision talks about what the Inspector General office is. The next provision of the city code relating to the Office of the Inspector General talks about what their duties are. Duties of the Inspector General shall be to receive all complaints of misconduct. So again, performing that administrative task of actually receiving a complaint coming from a citizen. Is that going to be electronically? Is that going to be in person? Is it going to be via some form? How is that going to happen? Those kinds of decisions are going to be made in collaboration with the Civilian Police Review Board, but then day-to-day, do I use this form or that form, is going to be the Office of the Inspector General. They will also receive complaints that are initiated by the Civilian Police Review Board for review. So again, the idea is that complaints coming from whatever source are going to initiate administratively within the Office of the Inspector General. And then, based upon policies established through rules and regulations of the Civilian Police Review Board, a decision is going to be made about what to do with those complaints. Are all of them going to stay in the Office of the Inspector General? Are some of them that maybe are more along the lines of rudeness or inattentiveness, should those instead stay with the Internal Affairs Bureau? If there are ones that are having a subsequent criminal investigation going on at the same time as the administrative complaint, should those be handled differently? So there are a lot of decisions that need to be made, but what is put forward in the statute is the idea that once those policy decisions are made about what complaint goes where and who handles it, that it's statutorily the Office of the Inspector General that actually performs the task of getting it to where it needs to go, right? So if so directed by the Civilian Police Review Board to investigate complaints of misconduct, and that's designed to encapsulate that idea of who's going to do the investigating of this particular complaint that's coming in. Last, to review and provide last on this slide, to review and provide a report to the Civilian Police Review Board on investigations conducted by the Police Internal Affairs Bureau. So again, it does contemplate that the Police Internal Affairs Bureau might still have a role here. The question is, what is that role going to be vis-a-vis the Inspector General and Civilian Police Review Board? And that's something that would be addressed in rules and regulations of the board. Next slide. Thank you. 4, to make recommendations on resolutions of complaints, and if warranted, suggest discipline, similar, and this suggests discipline to the Civilian Police Review Board. So you notice that while the Inspector General also has a recommendation role here, the Inspector General recommendation is not to the Division of Police. The Inspector General recommendation is to the Civilian Police Review Board. And then the role of the board would be to make those recommendations to the Chief of Police and the Director of Public Safety. To review and make recommendations to the Civilian Police Review Board regarding Division of Police policies and procedures, same thing. Inspector General, because they're doing the day-to-day work, might see a lot of small things that could be changed, or an inefficiency, or a pattern of bias in a particular area or precinct, or whatever it might be. It would be the role and the responsibility of the Inspector General's office to, in the course of conducting their investigations, to make those recommendations to the Civilian Police Review Board based upon what they're seeing. And to perform, again, such other duties are not inconsistent, that catch-all. Next slide. All right, before we go on to the effective date, any questions regarding the duties?
Yes, there's a question.
Excellent.
Is this on? Yeah. Just one question. Under the Inspector General selection, the board is charged with selecting the Inspector General by majority,
2/3.
2/3, with concurrence by the mayor. Does that mean that the mayor can overrule our selection?
So it's an advice and consent, it's an appointment and, what's the word? Not consent. Confirmation, sorry. That does mean that if the mayor had a concern, the mayor could address that concern. And the mayor could say, I have an issue with this, and I'm not going to confirm the appointment of the board.
So it would be the same with removal?
Yes, it would be the same with removal. Any other questions?
Yeah. So Internal Affairs can then make a referral to the Inspector General?
So the way that we have written it in statute is that this board would make a determination up front so that all complaints would initiate with the Inspector General. So it wouldn't be contemplated that the Internal Affairs Bureau would have gotten it in the first place. It would have started here and then potentially be brought to them. Now, I would imagine, and again, that's up to your rules and regulations and procedures within the department, that if there had been a referral to Internal Affairs and then something during the course of that investigation suggested that perhaps that particular investigation elevated or was different than had been anticipated at the time that it had been referred to the Internal Affairs, then the rules and regulations could contemplate IAB coming back and saying, I think this is more appropriate for the Inspector General. But again, that's yet to be fleshed out.
Okay, but that procedure is going to probably, no more Internal Affairs getting the complaints. They're going to go to the Inspector General.
Yes, the statute is written so that once the Inspector General, which is why actually this slide is important next.
Okay.
Once the Inspector General is up and running, that they will be the point of all of those complaints coming in, and that to the extent that Internal Affairs still conducts any investigations, it will be based upon policy set by this board, that this complaint is a complaint within policy that should go to them.
Okay, thank you.
Yes. I don't know who said first, I'm sorry.
Do you want to go, Kyle? Go ahead.
Just a quick question. In terms of the actual concurrence with the mayor, if there is, let's say, kind of a stalemate in terms of whether or not to move a particular candidate forward, is there a timeline set out there in terms of when a decision gets made?
There is not.
Okay. So there is a possibility that you have a vacancy that's left open because they can't come to an agreement?
Well, that's always possible. Any board or commission position that is created by statute, that's always a possibility. We've seen that at the national level as well, that could happen. What I would say is that the statute is written such that without the Inspector General being appointed, there's no way to do a lot of this work. So I think that might create its own need to have the position filled at some point.
Thanks.
Yeah.
So my question was logistically about the investigators that are going to be hired in the chief inspector's office. So I noticed in the job classification that it kind of mentions must be able to manage a large caseload. Is there anticipation of how large the office will be? How many investigators are anticipated to being hired?
I am going to leave that to Director DeLong.
Okay.
My suspicion is that there's a starting number, and then as the work continues, then that number will need to be adjusted one way or the other as there's a sense of volume comes in. But I'm not specifically aware of the timetable for those decisions.
Related, and it might also be the same answer. From the confirmation date of the chief inspector, is there an anticipated timeline then for filling those investigator positions?
And that I would also defer on. Yeah, I'm sorry, I
Okay.
don't know.
No, that's fine.
Sorry. I don't know, Janet, if you want to.
I think I saw a hand here.
The question I have is, for the day-to-day oversight of the investigator general, when that person is hired.
Is your microphone on?
It was green.
Okay.
So the day-to-day duties of the inspector general, when that person is hired, we might be in a situation where we're only meeting quarterly. So who is overseeing the day-to-day operation of the inspector general, and who is making sure that they are meeting the marks that are set by this board that they're doing the job that we have commissioned them to do?
So the Office of the Inspector General and the position of Inspector General is a director-level position within the city of Columbus. But the way that the statute is written, the oversight is with the Civilian Police Review Board.
So I would anticipate, and again, this may need to be a part of rules and regulations. So let's just say that there's not enough of a workload for the board to meet quarterly. Usually, the chair of an entity would have regular meetings with, in this case, the Inspector General. So at a minimum, I would anticipate that. I don't see a situation where we wouldn't meet or have communication or oversight for a 90-day time period. I'm sorry, is there, yes.
I'm sorry, I would like to go back to Board Member Strickland's question to you in reference to conflict between this board and the mayor in reference to choosing an inspector general. Is there a way that there could be some resolution process put into our rules as to how, in times of conflict, how that is to be settled?
Unfortunately, not within your rules. If there were to be, again, as the city attorney's office, I have no, I'm here to advise on the legal aspect of it. If there were to be a rule that would address how to address a stalemate, it would need to be in the city code itself.
Okay.
Again, is there another question?
Let me just say why I said that too, just so everybody has an idea. So your rules and regulations allow you as a board to enact regulations that are consistent with the duties that have been delegated to you in city code. What you can never do is have a rule that is more powerful than the delegation. And so since the decision about how the mayor chooses to confirm is outside of the authority of the board, that would have to be addressed in statute.
And if I might share, I could envision a time in the future, certainly not with this mayor, and I don't know the next, but let us just say that a mayor was elected in the city who absolutely opposes this board and its work. I could see such a stalemate occurring. I mean, an excellent point, and it's not as if it couldn't happen. I think from some of the work done by the working group that they saw communities where there were mayors in place now who did not approve of the Civilian Review Board. So that's, I don't know if the rectification would be that the charter would have to be amended, on something like that. That's rather, I don't want to say drastic, but excellent questions.
Again, Chair Jackson, if I may speak. I say this because we are the foundational team. And since we are going to be basically setting the foundation on how this board is to operate in the future, that's why I wanted to kind of piggyback on what.
And I don't know how this should operate, if you forgive the informality, Laura. And I give everyone, Chair or Janet, it's fine with me. Maybe this is something that should be looked at by the city attorney's office and to share and to advise us as to we think, might happen. It does seem early to be going back in terms of amending the charter. But again, it could happen in the future of the city.
We will do that,
Thank
Chair
you.
Jackson.
Were there any other questions?
Just one final one.
Yes.
Just writing it down. Okay, sorry.
Just one final question. Does a civilian have a specific period of time that they need to bring an event to the board?
Yes. So FOP contract still spells out contractual obligations on behalf of the city to members of the sworn police department, and that provides 90 days from the date of the incident.
And so if there is an incident that occurs on the street and an offense is charged, and the officer charges a civilian with an
Okay.
offense, and they have to go to court, that is not going to be resolved, in 90 days. So that individual is precluded from filing a grievance because they're going to have to go to court, and that officer will have a say in what happens in court because the prosecutor will question him. He will want input from the officer. So is that just something that needs to be worked out in the contract? Or is there something that we can do? Because 90 days there are things that happen and people, and citizens who are charged with offenses, don't have an opportunity to file, to go and air their grievances.
So to answer the first question, it is something that would need to be negotiated because it is part of the FOP contract with the City of Columbus. It's a contractual term. Regarding the second, and I recognize that there might be some practical barriers, but there's no legal barrier to that individual who's been charged with filing a complaint. The question is then, what happens with that complaint during the pendency of the criminal case? And so that's something that we can certainly address as this board moves forward. But I just want to make it clear that if you're charged with a criminal offense, it doesn't prohibit you from filing a complaint. As I said, there might be concerns that you might have regarding what that complaint's going to state, but it's not a bar.
And I would anticipate, and I think it's more around the timing of the hiring and having in place the Inspector General. There's a responsibility, I would say, on the board and the Inspector General to educate the public about this. I mean, we've not done any of this at this point, and I don't believe that we should until the Inspector General is in place. But I could see where, as a matter of fact, there's been very little from us in terms of the public at this point in time. I would also just think, Mary, that members of the Bar Association who might be representing these individuals might need to be educated on this and this process. And those are just two of my early thoughts, around this. But certainly with the Inspector General in place, and I don't want to call it in any way a marketing campaign, but we need to share with the community, with our citizens, what they can anticipate with all of this. So Kyle, did you have a hand up?
So kind of to that point, there's nothing precluding necessarily the board putting in place, some sort of tiered structure of how they receive complaints, basically, in terms of, let's say a process is going to take longer than the time period, but then if there's a type of complaint that somebody wants to file, is there anything precluding the board itself setting up some sort of tiered process where one is more fast-tracked in a certain way? Is there a way to do that?
There's a way to set up tiered processing, but it has to also be in harmony with the other provisions of the contractual obligations the city has to the FOP. For instance, there are specific provisions of the contract discussing how long you have to conclude an investigation as well. And there are things that can toll that time.
Okay.
And we're probably getting too far down for this particular meeting, but we would need to be cognizant of those obligations that city has already made in the contract, and then make any kind of rule or regulation that is consistent with those terms as already provided.
Okay, thanks.
Brooke? And then, Aaron, did I see your? No, okay.
So related to the same kind of conversation, two additional quick questions. Is there right now a limitation as to who can file a complaint on behalf of someone? So thinking about the scenario where someone is incarcerated in a local lockup, is a family member who is present or something like that?
I'm phoning a friend. Thank you. Deputy Director Speaks is behind me and is confirming for me that anyone who has knowledge is able to file a complaint. The question is, of course, in any particular case, who has knowledge, but anyone can file.
Okay, and then related to that, those complaints that are filed with us, also thinking back to the scenario that Mary raised, at what point do they become public? Is it immediate, or is it after our work is done, or the chief inspector's work is done, or is there a limitation in the FOP contract about that?
There are a couple different considerations, and that's really going to depend upon the specific complaint that's being raised. If the complaint, again, without getting too much into the details, but definitely if the complaint raises an allegation of a criminal violation and it is then processed as a criminal investigation, then the public records law are going to treat that differently than a purely administrative investigation. And so at some point, the rules and regulations of this board are going to have to address how to deal with determining that something has to go that route.
Okay.
And that will determine whether or not it's public.
Thank you.
My suggestion would be that we have a review of the FOP contract as a board, especially around just cause discipline and discharge and a grievance procedure.
So noted.
I have one more slide.
Okay.
So as you're already starting to get the sense, there's a lot of work that the statute has placed at the hands of the Office of the Inspector General and this board. And as you also already have a sense, we don't have an Inspector General yet. So it is really important to note that the provisions of the code changes that I just went through, the effective date for the duties of the Inspector General have a delayed effective date. So every other provision that we've discussed here this afternoon is already in effect. It was voted on late July, and it's in effect. I can't remember the exact effective date, but it is in effect. However, the provisions specific to the duties of the Inspector General will not go into effect until 90 days from the mayor's confirmation of the Inspector General's appointment by the Civilian Police Review Board. And that was done very intentionally to avoid the problem of if the minute the code goes into effect, suddenly the Inspector General has to start receiving all of these complaints, and we don't have an Inspector General yet. So there will be a ticking time clock from the time of appointment to when that Inspector General's office then needs to be up and running to the point that they can start receiving complaints from the public. So that will be very much a necessity to have rules and regulations in place to deal with that. And then as their work continues, then the board will need to be thinking about, okay, now they've received complaints, and now we've decided who's going to do the investigation, now what? So just be keeping that in mind, that there is that ticking clock running 90 days from from confirmation. So that was my presentation on the city charter and the city code provisions.
I'm going to change the order of the agenda.
Okay.
So I'm not going to have you go directly into bylaws.
All right.
What I would like to do, the discussion of the Inspector General's office and job description. So you would have received the proposed specification of the position of Inspector General. And quite frankly, I'm not leading a discussion on that today. I wanted to share some information with you. So the city has retained the firm that will lead the national search for the Inspector General. The individual who is leading that work, his name is Robert Berg, B-U-R-G. I had the opportunity to have a conversation with Mr. Berg and members of the team. He wants to speak with each of you, so your names and telephone numbers have been given to him, because he wants your perspective of what you want to see in an Inspector General. What are the qualifications, et cetera. But if we have time today, and I just want to plant the seed, would just like to do a round robin here in this meeting today for you to share, for example, what's the most important thing to you at Inspector General? I'll just give you an example. For me, it's the experience that the person brings to the job. What might be others? We told him we would capture those, today, but give you enough time to really think about when you have that conversation with him. I also ask about time frame. So the administration has used this gentleman before, and his firm was used for the chief of police. That process also would have had an impact on the new safety director because he was a part of that. I've been reassured that if the city does what it's supposed to do in terms of timing, so for example, our conversations and collecting information, that when he gives you a guesstimate of how long this will take, he's usually been pretty good. So what he said to me, and he laid out more of a timeline, I just want to kind of get to the end date, that he believes that an Inspector General could be in place by the first of the year. I think his process is actually sort of 45 days. So I will talk to you about this maybe more at the October meeting, even having to outline a process for how this board is going to be, involved. But I just wanted to plant, that thought with you now. And, we keep talking about the Inspector General, and you must be saying, well, when is this person going to get here? And so that gives you a little bit of an idea of the timing on this. Any questions on that? So again, I would suggest that you kind of reread this. And then, of course, in the bylaws, there would be some more information about the Inspector General. So if there aren't any questions on that, I'm going to make one other change in the order of the agenda, and that's the review of the social media policy. So I found out that policy was adopted and put in place, I shouldn't say adopted, it was put in place for the use of the Safety Advisory Commission, which Ms. Burns served on. So you had the concern, I recall, about, the one item. So you want to restate that? And I guess the best thing to resolve it is just to open the floor up for discussion, and then we would need to vote on it.
Sure. So I have brought attention to the first one, which was simply impair, there we go, working relationships with the city. And I'm not sure that really tells us, I feel like there's a lot of deference there as to what that actually means. And so I know that a number of us work in areas that relate specifically to criminal justice. For example, I'm a public defender. And so impair, I'm just concerned about how loosely that can be applied.
Would you want to take on working on the wording
Sure.
of that? And then we'll bring it back?
Oh, certainly.
to
I'm
the
sure
next
no one
meeting?
wants.
And I don't know if there's anyone else who wants to work on that, but again, I think that was the only concern that was addressed about the policy, was that very first one.
And I will say that the language, and I'm not saying that you don't have a concern with it, I get what you're saying. The language likely came from some of the First Amendment cases dealing with the direct employment relationships between employees and supervisors, specifically impairing discipline or impairing, but I certainly get that the board's relationship to other members of other public officials in the city is a little bit different than employer-employee. And so certainly some language to address that difference might make sense.
I think that would be helpful simply because taken by itself, I think that lends itself to a wide interpretation. And so knowing how much public scrutiny is going to be and has already been on just the board's activities and even forming, I think it's important that the language that's here reflects more closely aligned with what that standard is, instead of just the way it's written.
So I would suggest that the two of you have a conversation and a redraft of the language, and it'll be brought back to the board in October. Does that work for the board? Good. Thank you so much. Now, I need at this point to apologize to the board because I'm the one who sets the agenda. And we went from a 2-hour meeting to a 3-hour meeting. And there's not a break included there. So, in the meeting. And I am one who needs the break. So, I see where it is, and I don't know what this does to the public filming, whatever. I see that it is 3:15. Let us break and reconvene at 3:30. Please be in your seats at 3:30. Thank you. Our board meeting. Director DeLong of the Civil Service Commission wanted to share some thoughts or ask questions of the board members about the position of Inspector General.
Absolutely. Chair Jackson, board members, I'm here today to talk about the classification specification for the Inspector General. Like you, we are governed by the charter, and the civil service has rules and regulations that actually give structure to that charter or more detail. So as a part of that, we are responsible for the development of the class plan, which includes all of the classification and specifications for the city of Columbus, which we have about 650. And as a part of that, the classification specification is a broad overview of what the position is. Today, we've provided that in a folder along with the investigator, which are the two new creates that my department would have to create as a part of this new department. Normally, we would go to a department and say, oh, you want to create a new position, can you give us the details of that position? But because we have no department, we have relied on the code and the charter to give us a foundation for what we have in your folder today, but would like to gather more specific information if you have examples of work that you think need to be included. But if you give us details outside of that broad spectrum that we'll use to develop that class plan, and then submit to HR to develop the salary for that position. So it's a process. So once we're done with you today, and we have the broad overview of it to make sure we have everything we need, it will actually go down to our compensation manager in HR who develops the salary, and then that compensation level, which we know pretty much starts out at least at a 98 because of the development of what the code already tells us. It's at the director level. If they see anything else based on what you're providing or additional information across the country, which we've already also looked at that, I don't think there will be any difference in that. Then it goes actually over to council to legislate it. So it's a process, and we want to make sure we have all of that done so when they're ready to make the hire, when you're ready to make the hire, that information is ready to go and you can hire them. Because without all of that done, it becomes problematic because there's no salary set for that position. So, that being said, I brought the person who actually does all the work in developing it with me. If we can have any input based on what you're seeing there, the investigator's separate, and we can talk about that separately. That position will most likely be, I'd like the Inspector General to have some, at least input. Now, we can go ahead and submit what we have to the commission, get a salary set, and based on the initial draft, which I don't usually like to do, but I know this needs to move quickly. In 2 months, if you guys work with the Inspector General and say, we need more than this is not enough, we will update it, which then doesn't have to go back through legislation, doesn't have to go back through everything, unless it becomes a much higher level position. And then we'll look at compensation to adjust that. But it keeps it moving and allows you to make that higher more quickly, which I think is what you guys will need to do as a part of that process. So if you have any additions, updates, thoughts, we would love to have those. And if you want like specific details about how we do it, I brought her because I wish I could tell you I knew every detail from the bottom to the starting process, but I don't.
So the draft specification that's before you is written at the director level, which this classification would be. I really didn't stray too far from actual city code language. There's some examples of work that are fairly standard that's used in all of our other directors. So there's some standard pieces that are just common to a department director, and then kind of the really specific stuff is largely taken straight from city code and just formatted to fall into line with the way our specifications are generally written. This is unclassified, so there are no minimum qualifications by civil service standard. Being unclassified, you will be able to determine exactly what your preferred qualifications would be for this particular position, but there would be no qualification review at this level, which is true with our other directors as well.
In your process, so far, have you reviewed the proposed bylaws that we're going to discuss today and to approve at the October meeting? And I just ask because there's certainly language or ideas in that.
Mm-hmm.
So have you done that?
I have not seen the bylaws, no.
Okay.
But any of that information that you would like to have incorporated, I mean, that could easily be incorporated.
Chair Jackson,
I
I don't think mine's on anymore. If the board is comfortable with that, I'd be happy to share the bylaws as well.
Please do.
Yep.
Okay. I don't know if we came prepared to give you input today.
Okay.
I mean, again, I just shared with members of the board sort of a briefing about the process, et cetera. And of course, shared with them that Mr. Berg will be talking to each of them, well, I'm not sure exactly when, I would guess the next couple of weeks. He's going to reach out to them. I don't know if he, and I'm looking at Kate, if he does a summary of those conversations. So he's going to talk to each member of the board around their thoughts for this position. Does he then create a summary of those conversations? And would we be able to review them or have them be a part of the process?
I'm not exactly sure how he'll go about this.
Okay.
We just haven't from the fire chief and police chief searches. I'm sure that if that's something that the board would like, that he can certainly do that for us.
And actually, I can contact him and talk to him, about that. Any other thoughts from board members about this process? Yes, Reverend Tatum?
I just need some time to kind of internalize a lot of this stuff, especially since we've got other information that's going to be shared with us today, because I can't speak for anyone else, but just like in anything that goes on in my business.
Is your mic on?
Sorry. Just like with anything that goes on in both my professional and private life, I don't make decisions on the spur of a moment. I like to give it some thought, at least make an educated determination on some things. So I'm really not prepared to do that.
So this is what, and I absolutely understand your point. Other members may feel the same way, even in terms of sharing their perspectives today. You may or may not feel comfortable, but I wanted to make sure you knew that you were going to be contacted by Mr. Berg, so you would be prepared to share, your thoughts. So with that in mind, I think certainly one of the things that I can do is then to reach out to him and to see if he's gleaned some thoughts, about this that we should share with you. I am reluctant to say that I would bring it back to the board in October for a discussion, because I think we're going to have, when I share with you the agenda for the board meeting, I think we're going to need the entire 3 hours for the 2 items that we're going to have. Did you have your hand up, Kyle?
Thanks, Chair. Well, thank you so much. One of the, I think generally, the framework of putting together kind of the draft where we'll have a sense of what a salary kind of range might look like, I think that'll be important. I think as far as these specific examples, it says may not include all the duties performed. Anything that we could add on from those bylaws that we eventually share over to you are just kind of the immediate steps. But I think the initial proposal of kind of putting some piece together, a little bit more full of a draft that incorporates some of this, then helpful for our review. And if we had some time, maybe ahead of that October meeting to see, then I think that might help kind of us think about some of these decisions.
Right. Ideally, just not having a blank page is helpful, I think, to see some words on a page and kind of get an idea of the kinds of things that could go into the specification, whether it's, you like this piece, you don't like this piece, but it's all just an opportunity to kind of begin thinking of this is the kind of stuff that could be here, and hopefully will trigger some thoughts and some ideas compared to a blank page.
Please do.
So I just want to also, just to reiterate what Director DeLong had said, and just to make it really, really clear, for those of you who are not familiar with the way the city does this, what you have in front of you is a job specification. It's not the same as a job description. So I just want to make it really clear. It's a broad category that's supposed to define the outlines of what that individual's job responsibilities and roles might be. A lot of them have reaching with hands and feet and, being able to speak. They're more specifically broad, purposefully to allow then for any individual hire to have the general criteria, but the job description is what describes really their day-to-day work, and that would be a separate document apart from this one.
Thank you.
You have a question?
Yes, just, their office will not be in the police department, is that correct? I mean, the Inspector General's office, it's separate and it will not be located within the Division of Police, is that correct?
It will have its own department number that sets it apart and makes it separate and apart from any other department in the city. So, I mean, physically, I don't know exactly where the offices will
Okay,
be,
so-
but it will have its own department number, its own authorized strength. It has its own section of code that sets it
Okay.
apart.
But at this point, you don't know if it's going to be housed within in Marconi Boulevard or
I don't know where it
Don't know
will
yet.
physically be housed.
physically, yeah.
Pardon, Kate?
It will not be there? Okay.
I was also looking, and this might be helpful to you, and I certainly don't have time to read them all now, but you might want to take a look at the report, the Civilian Review Board Work Group Report and Recommendations. They had specific, and again, this is just kind of for the thinking. They had some specific views of the Office of the Inspector General. So if you don't have that, I would suggest that you get it.
Will do,
Okay.
thank you.
All right. Thank you. Director DeLong?
Just one quick note. The director level salary, because I know that's been a big question with everybody, it starts out at $121,410 and goes up to $202,342. When we look at like LA, Denver, Chicago, Seattle, all those different places that are currently hiring inspector generals or have recently hired, we're definitely in the ballpark with our salaries. So I wanted you all to know that. So hopefully we will be able to get the best in that range.
It's not going to be hopefully. We are going to get the best, okay?
I like that.
Thank you. Okay, thank
All right,
you.
thank you.
And now we will return to the agenda, and we will go to the bylaws. I'm sorry.
I have a question for the IT. Can you all move the light over? It's like right in my eyes. Is that possible?
It's right here.
Oh.
And it is something that I can tell you from the Safety Advisory Commission in terms of how they do this. They can't fix it.
Oh, okay. Well, that's fine.
You know, it is literally, you know, right there. So I understand, but I've been there and fought that battle and lost.
I have one too.
Oh, yeah, okay.
Bylaws?
Thank you. Thank you, Chair Jackson. Does everybody have a copy of the bylaws in front of them? I don't have a slide for this.
Oh, okay.
Sorry. But I did want to kind of walk the board through the different articles and solicit some feedback now and see how many areas there are where there are going to be conversations that need to occur now, how much discussion needs to happen, how many are places where there is a consensus and there's not much need for discussion, just so I have an idea for what might need to be worked on going forward. So I'm pretty much just going to lead the discussion, but with the permission of the chair, I'd like to hear from the members regarding any concerns or thoughts that you might have, and I'm certainly going to help guide that conversation because there are specific areas that I know need your feedback, and others are just more standardized terms. And so let's start with Article 1. I am not going to read all of this, but I will say, Section 1, scope of the bylaws, is pretty much just establishing everything we talked about earlier this afternoon, where the authority comes from.
Let me interrupt for just a moment. I want to make sure that all members of the Civilian Review Board, and I realize I might be seeing them in a different format, that you have the most recent draft, which is dated September the 3rd, 2021. And I also want to take this opportunity to really thank Laura, because certainly she worked on these and other items during this past holiday weekend. We greatly appreciate you and your work. Thank you.
Thank you, Chair. All right, so Section 1, as I said, is just scope of bylaws. It's pretty much statutory legalese. Section 2, certification and publication of bylaws. This provision also is really informed by and comes directly from the city code. That's just the process by which generally boards and commissions publish their guiding documents. So there's not much room here for tailoring to any particular board or commission. They pretty much all read like this, the Section 2. Section 3 is the first place where we need to start, where the board needs to start deciding how it wants to address certain issues. So the board may amend these bylaws from time to time, and this is the part I want to draw your attention to, by a majority vote of the entire membership of the board. You're going to find that throughout the bylaws and throughout other provisions of the statute as well, there's often a discussion about what number of members of the board have to be in favor of a particular item in order for it to pass, in order for it to receive board approval. And in some instances, it's very clear. For instance, a general motion, like we have right now, I move to approve the minutes, is generally just in order for that to pass, it's usually just a majority of the members who are present at the meeting. And that's common for how boards will act. But there are other items that the board considers that might be of such a higher level of importance that you want to consider whether or not it's important that it just be a majority of the people who are present, or if you want it to actually be a majority of the people who are on the board. So for instance, there are 11 seats on this particular board. And let's say that you had some individuals that were unable to attend, and instead you had enough for a quorum, so you had 6 people of 11 here to vote, but you had a matter before you that was really important to the board, like for instance, the Office of the Inspector General, right? Statutorily, for the Office of the Inspector General position, it says 2/3 of the board, all right? Other provisions don't have a specific requirement for if it's going to be of all board members or just of the board members that are present at the meeting. The second thing you have to consider is that, again, going back to the Office of the Inspector General, 2/3 of the members of the board. Right now you have a vacancy. When you're saying 2/3 of the members, do you mean 2/3 of all 11, in which case, in order to pass, you would need a higher number of people agreeing to that because you have a vacancy? Or do you mean 2/3 of all the people that are currently appointed and seated on the board, in which case it would be 2/3 of 10 rather than 2/3 of 11? So their bylaws are where you address the issue of what you need in order for something to pass, and whether you're basing it upon people who are present at the meeting or people who are on the board or the number of people that could be on the board. So going back to this question, when you're talking about amendments to the bylaws, the board may amend these bylaws from time to time by a majority vote, and this says of the entire membership of the board. What you're going to find a little further down the line in the bylaws, it's going to be on the next page, we're going to get to it in a second, is we're going to have a conversation about what constitutes a quorum. And does the quorum contemplate vacancies or not? So you don't have to give me the whole, but I'd like to hear from the board in terms of, number one, the first question is, are there things within the bylaws that you feel should be based upon the full membership versus just based upon who's at a particular meeting? And then number two, if membership is going to be everyone who's currently seated on the board, or if it's going to be required that you have a majority of the seats on the board, which means it would always be 6, even if you have a vacancy. So that's the kind of feedback that I'm hoping to get.
If I could respond to the second one, because I would, 2/3 of those seated versus rather than 2/3 of the number. I'm in favor of 2/3 of those seated because I would not want our work to be impeded by a resignation or there being a vacancy. I'm assuming we're talking about a really small number, one, maybe two. And I probably just broke protocol by the chair sharing an opinion first, but on that particular one, that's how I feel about it.
There's nothing worse than going to a board meeting and not being able to accomplish your business. So whatever we agree upon, we need to make it so, whoever shows up can make decisions.
Except I would say if they're major decisions, and we're going to have to figure out what's a major decision, excellent example about hiring of the inspector general, I would want it to be far more than 6 people.
Then we need to carve those out.
Yeah, we need to decide what those incidents would be. I'm sorry. I don't know who was first.
My question, or my feedback is.
Is your mic on?
I pushed the button, but it's green.
You just might need to speak up a little bit.
Can you hear me now? Okay, perfect. My feedback is, I agree with the chair that it should not impede the work that we're doing. However, I do feel like the voting should be consistent across the board, especially for things like bylaws, which really dictate all of the work that we're doing moving forward. I think it should be one consistent manner of voting, because when you have to pick and choose how you vote and what's applied, I feel like that causes a lot of unnecessary confusion around how things work.
Kyle, do you have a comment?
I think right here it says by majority vote. I think 2/3 vote, and I agree with Chair Jackson on the actual membership of the board side of things.
Can I ask the question, is there any member of the board that disagrees, that says it should always be of the total number of seats versus the number appointed or and seated?
Would that be of those attending?
I'm asking, that's a separate question, so I'll get to that as well. So my question is, for something that requires a majority vote or a 2/3 majority vote of the board, something that you've carved out as being special, right? Is that going to be of the people who are currently seated on the board, appointed to the board? And I think that's what I've heard from Chair Jackson, and I've heard from Member Strickland. I couldn't remember the title. Is there anybody that disagrees with that first, and then we'll go on to the second question, because they're related but slightly different.
So actually, the only thing I would say, I agree with what I'm saying, but if there was a scenario in which, let's say there was, mass resignation or something like that from the board, and then in that scenario, would you want a couple members passing a bylaw to amend the bylaws to make changes happen? That's the only potential scenario in which I think that would be a problem, but other than that, I think I'm fine.
Having some sort of minimum number that, in other words, but never below X number of people, so that if there was a controversial issue, if, for example, there was a massive, resignation because of some impasse, so that we find ourselves really having a significant conflict that isn't being resolved, you might want to, because the bylaws, the working group had an 11-person board. What you wouldn't want to have happen is below a minimum number having, decisions made regarding an investigation or something, so that, but never less than 7 members or 9 members, something like that. That's what I'm.
Any other feedback? Okay. So then as we go through the bylaws, it's important for me to understand which of the things in the bylaws that the board votes on fall into that more special category where you need a larger number of people present in order to pass that kind of thing, versus what's just your standard normal operating, in which case, the way that it's written right now, just a normal board meeting, just to do your normal business, so long as you have a quorum, then it's just majority vote. Is that comfortable with everybody? Okay. So bylaws or the amendment of the bylaws was one of the first places where that was delineated as being slightly different. Is that comfortable with the board that the bylaws, their amendment of the bylaws should be in that category that requires the majority of the board? Not just the
Yes.
majority of people present?
Yes.
Okay. I hope I'm explaining this. All right. Purpose and authority, section 4. The purpose of the board, this comes directly from,
Hold on,
again.
Laura.
Oh, I'm sorry.
I have one more concern, and it's 3.
Oh, sure.
At least 5 business days.
Yes.
I think that should be 14. That we get further notice out than just 5 days if there's a change.
Is there discussion on that point by other members of the board?
I would just like to ask, why do we have to have 14 days? That's all I would like to ask.
Well, you're very,
Why do we have to have 14 days? I'll make sure they can hear what I said.
your very comment earlier about you'd like to take time to think things through before you make rush decisions. That's exactly the purpose of that.
I'm trying to anticipate our meetings. So right now, we're meeting monthly, and I believe that we will continue to meet monthly for some period of time. And then again, just trying to think through the scenario of someone drafting, the amendment, maybe it coming up in a board meeting, there is a request for someone to attempt, to draft. 14 days seems a little long to me in terms of the schedule, that we have.
It shortens the other period for drafting. If something comes up in a meeting in September, we then turn it over to somebody to draft. They only have 2 weeks to complete it, get it to the board in order to give us the 14-day notice so that we can then mull it over for the October meeting. 5 days gives you a longer period of time for the kind of administrative work that would get to the board so that we could review it for the next meeting.
So is crafting then more important than the discussion?
Well, the discussion would happen at the next meeting.
Yes, but the review process of 14 days, so crafting the thing, having more time is more important than the actual ability to discuss it before the next meeting.
I'm going to ask a question of Laura. I know that you work with a number of boards. I won't talk about the commissions because boards are different. Is there sort of a standard time period that are found in bylaws?
Yes. So the standard time period is what I placed in here, the 5 business days. It can be different, but that is the standard.
Okay.
There's nothing precluding if we needed to, table a particular proposed bylaw. This is just the 5 days is so that we have a reasonable amount of time to review. But then if for whatever particular reason there was a major issue, there's nothing precluding anyone from saying, hey, I don't think we had enough time. There's also the process in place in which we can make it a practice or standardize. We would like to, give you 14 days to read something. But if we needed to, that 5-day time period, I think, seems like a fine best practice.
All right, so would everybody be more comfortable if it was just 7?
I could live with 7.
Works for me.
7 days or business days?
7 business days.
Business days. Thank you.
Okay. And as I said, section 4 and 5 are really very much standard. Section 4, purpose comes from the statute, and section 5 is just saying if there are any definitions. Any other thoughts, concerns, questions, or issues that you wanted to raise regarding Article 1? Fantastic. Article 2. All right, section 1, appointments and terms, and this comes back to the question that we've already discussed a little bit. When does a quorum exist? I think that I have heard the members. I will try to draft something based upon what I've already heard. If, as we go through the rest of the bylaws, something that I say or something that another member says sparks you with a thought regarding quorum, please feel free to still raise it for me so that I make sure that the language is what you need it to be. But if not, I'm going to move on to the other things in Article 2. Okay. So appointments and terms, a lot of this is directly taken from the statute. Staggered terms, okay, but the first thing that's new is the third paragraph in section 1. A board member who for any reason seeks to voluntarily resign from the board shall do so by submitting a signed, written letter of resignation to the board. The chairperson of the board shall send notification to the administrative coordinator, I'm going to come back to that in a second, requesting replacement of the member by the mayor as provided for in section 235.01. Any member appointed to a position that has been vacated prior to the expiration of the position's 3-year term shall be appointed to serve out the remainder of the unexpired term. That last sentence is to make sure that the terms stay staggered, so that any individual who voluntarily resigns, if somebody's appointed, they're appointed to fill that unexpired term, and then they could seek a term for themselves after that, but otherwise we would mess up the staggering of the terms, so that's why that's written that way. But the rest of that sentence are any issues, concerns, thoughts regarding the process for somebody who wants to voluntarily resign. It is my recommendation that you do have it in writing. And that can certainly be via email. It's preferable, I would think, to have an actual letter that's signed, which is what I've proposed here, but I'm obviously open to hearing from the board in terms of if there are any concerns that you have about how it's drafted, or if it's too formulaic, or if you have any comments at all.
Since I just worked with this over the last few days, the one perspective is that it has to be a signed letter. In this date and time with technology, would an email to the chair not be sufficient?
It would be for me, but the question is if that's.
Any other, yes, it comes to the chair of the board.
Does it? Oh, it does. Yeah, that's a drafting error. Okay, that I can fix. And so signed is off, written letter. Any other thoughts or comments on that section?
I have a question. In sending that via email, it would be over the city web's email, right? Via
Yes.
city email.
So it creates a public record.
Okay.
But this to me now becomes a public record.
Okay, I just wanted to make
Yeah.
sure that needs to be understood by the person resigning. They don't send it to Chair Jackson, on her public email, but on the city's email.
Well, I don't have a public email, so it would be my city email.
The only reason
Yeah.
why I'm saying that is because we don't want to have an instance where somebody else sends somebody's resignation letter to you, and they haven't really resigned. Because we know people play tricks on email. That's the only reason why I'm bringing that up. But since you said you don't have a public email, there's no problem.
Right, I mean, I have a personal email. I mean, again, my public email would be the city's.
Okay.
And I
Well,
understand your.
I've got it flipped.
Yeah,
Your
and I
personal
understand your
email.
point, but I think there's a certain reality, and this isn't a huge issue for me, but of how we operate today. because I had had conversations with Mr. Sistrunk, and he had shared with me what he was planning on doing. And there were others I was able to facilitate, I mean, even today, because I thought this was so important, I needed to get this to you today, not wait until the October board meeting, that someone was able to pick this up and bring it to me.
Okay.
Keep a comment over.
Yeah, the comment I have is not specific to, I think the email is fine. It is around the replacement process. Wanted to know if there's any thought around in consultation with city council or what that process is, similar to what the process was for appointment in the first place here. So I just wanted to check there if that was.
Yes.
Yeah.
Yes, so the reference that it would advise the mayor to replace the member as provided for, 235.01
Great,
does
okay.
contemplate that process.
Great, thank you.
All right, moving on then to section 2. This is the comprehensive training program. So as we talked about when we went through the statute, there's a requirement that this board prepare and provide for what's going to constitute the comprehensive training program. And most of the language that you find here in section 2 is just a direct quote from the statute, laying out the specific course of training and what that training has to consist of. Down below, the language that's specific below that, that's numbered 1 through 5. Thank you to Robert Tobias in my office who put together some of this language. But that is designed to be the city attorney's office recommendation for what the characteristics of the programs that meet those particular criteria would be. And then we've also provided to Chair Jackson a list of suggested contacts and suggested programs and trainings that meet those definitions. So I wanted to hear if there were, A, any concerns with any of the language that we've provided in 1 through 5, and B, I also wanted to know, these are the statutorily required components of a training program, but that's not a limit. If you wanted, the board could require additional training if it chose. And so I want to know if there are any additions or thoughts related to the training program.
I'm sorry,
His hand was up first.
Pastor.
Yes. Doing something, there we go. I'm concerned about before we get to the specifics of the training, that language of prior to beginning their duties.
Yes.
We're operating.
But we aren't really involved in duties when it comes to the important work of, because we don't have an inspector general.
We don't, yeah.
So this is how I interpret it. The duties, the real work will start. Our work will start after the inspector general is in place, and everything that you heard around accepting, complaints, moving forward with complaints, with the inspector general. We are now in the process, and that's why I've been working so on the training to get us ready to perform those duties.
Yeah. But another way to think about our responsibility is that one of the most important responsibilities we have is choosing the inspector general. That's one of our key duties. And to complete this amount of training while we're in that process of choosing the inspector general might be problematic. And I just wondered if we might want to say in the first 6 months or give us a runway for doing all of this training. We're even having problems scheduling the ride-alongs because, and that's just, to be expected. Folks don't get back to you, you're having a conflict in your schedule, you're out of town, all of that. It was just that language prior to beginning their duties that stumbled me.
If I can jump in, I understand the concern. The initial board is treated a little bit differently in the statute than subsequent members are, in that there's a recognition that you're not up and running yet and performing your duties. And so the initial board is given until their term of office, their first term of office is over to complete the training. And so while there is a desire, for the reason that you stated, to have some of that training under your belt before you pick an inspector general, there's also a recognition that you guys are in a different position than other board members will be.
Aaron?
Okay, my suggestion for this section of the article is, I would like to see that expanded in here. I think that one of the conversations that we keep coming back to is that we're establishing the foundation of this group. I would like to see these trainings expanded in the bylaws so that, for instance, when the board changes, as it inevitably will, that there is a base level of, more expansive, more encompassing trainings that we offer for our members. For example, one of the things that I think should be included on here, on top of what has already been, written in the structure, is how to conduct investigations, right? So many of us have, or speaking for myself, I've never conducted an investigation, right? So that could be helpful as, and I know I wouldn't do it obviously all on my own, but how do you take this knowledge that you're presented? How do you turn that over? How do you apply that into the work that we're doing? So I think as we are establishing a foundation, we can flesh out some more opportunities that are written in the bylaws for groups that come after us to adhere to as well.
I would ask this question: does that need to be a training, or could that be what I would call an informational session? Certainly, I plan at one of our future meetings, and I wish that I felt we had the opportunity to have just more time on the agenda for open discussion. I feel pressed to move to get this training, done, so that we really will be ready to do the work when the Inspector General comes. But certainly, I anticipate just having a session around whether it's additional trainings, individuals that you would like to talk to. I don't know, and I truly don't know, so I'm asking this. Does all of this need to be put into the bylaws now, or can we give ourselves some leeway, as individuals to say, well, I really want to hear more about this or about that. And I guess the word I'm looking for is flexibility, having more flexibility as we move along, or do we feel that we need to have everything codified at this point? That's, because I'm going to be, as your chair, I'm going to be very open to that. I feel that in terms of from now to the end of the year and getting the Inspector General in place, that certainly what's here, and I'm not saying we can get all of this done, is the most important, with other conversations, and not trying in any way to not have suggestions now. I'm going to always try to explain to you what my thinking is as we build this board.
I guess my only, and I appreciate that, I guess my only response to that is if we are codifying everything else as well, why not these kind of smaller level things, I guess? But I totally get that, it may not belong in here, but that was just more of a suggestion to put that in there. But if we are taking the time to review all of these, I think it's an important step as well.
And we might easily add it, well, I'm not sure, under item 3 in terms of seminars, because to me, this would be a seminar. What you're talking about.
I think to that point, I think adding more to the required trainings, I think it's already a lot for volunteer members, especially future iteration of the board, to do. And so I wouldn't be in favor of adding other required trainings, but I do think the language that gives the flexibility for other seminars, history, other dynamics that I think would be important, investigations, I think is key. Mm-hmm. The one thing I will say is that similar to us being appointed as board members and then taking the time to schedule trainings and things like that, I think there actually should be more runway time for even new members because, for example, let's say somebody vacates or their term is over, they're supposed to be in their seat until somebody else is fully qualified and ready to go. So my worry is that somebody might have issues with the training timeline and things like that, and then that person is having to stay in their seat until their term is done. So my recommendation would be to, similar to Pastor Nathan's point, to have a little bit more time for members to have to complete all these trainings.
Unfortunately, that's going to require statutory change, but it's certainly something that I can pass along to city council, because
That's in the statute.
it's in the statute.
And is there a, if somebody is attending something in person versus virtual, or, because I'm just trying to get a sense of like how many hours are we expected to do on this? Because it could be a shortened version of something, a version of these if needed. Because that's my only concern, is that this is going to take a while, you never know with pandemics and things like that. I think those are some of the concerns that I have.
So the way that the bylaws are written is to structure what the training would be, but not to mandate the specifics of the training. So the board can determine at any point in time how many hours it will be, and will it be virtual, as long as it meets the criteria that's laid out in the bylaws. And that's designed so you don't have to amend the bylaws every time that there's a change, for instance, in who's providing the training or in the hours of the training.
Other, yes.
I was just going to ask if this could be simplified by just stating that these topics are the required floor or minimum, but that whether it's the chair who brings and puts things on the agenda or the members themselves who have questions, it feels like other content could be added with each, with each board.
Sure. And definitely, I mean, even the language that's used here is because there's a statutory obligation on the city attorney to provide guidance, but we tried to make it clear that it likely will include, or it can include, to address those very specific concerns. We want to make sure that we meet the minimum that's provided for in the statute. You can always do more.
Continue.
Okay. The one other question I had about comprehensive training, that is something that you may not need to address in this first set of bylaws, but just something that did come to mind, you might want to keep in the back of your head for the future. This only addresses initial training. So you also want to think about whether or not there should be any kind of obligation on a board member who's done this training to redo any other parts of it during their service. Again, that's not something you have to think about now, but just want to point out that it only addresses one time. So if you serve a 3-year term and then you get appointed to serve a consecutive 3-year term, conceivably you could have a board member that only did this training once 6 years ago. So just keep that in mind. Section 3, removal of a board member. This is an important one. Obviously, it goes to how you control your board and how you deal with members that have become problematic. And hopefully that won't happen, but I've done enough board work and commission work to know that it's possible. And so it's something that the bylaws really do need to address, so if an issue comes up, you know the process. The first part is, as you can now see, that first paragraph is direct restatement of what's in the statute, so that's not movable. The rest of this is coming from recommended ways that other boards and commissions deal with this particular situation, and also how we might address the specifics of the statute as relates to failure to attend meetings or to complete mandatory training. So the second paragraph, board members must attend every board meeting, or if unable to attend, seek to be excused from the meeting by the chairperson prior to the meeting. Again, none of this is set in stone. This just comes from other recommendations. Any board member who shall have been absent from 2 consecutive regular meetings of the board without just cause, as determined by a 2/3 vote of the board members present at a board meeting, shall be deemed to have neglected their duty, and the board may seek to recommend to the mayor that the member be removed. The board shall consider each absence of a board member a separate circumstance and may expressly waive such absence by a 2/3 vote of the members present at the meeting. So what we have set up here now for your consideration, and this is all subject to however you would like to do this, is how to address, first of all, circumstances where a board member fails to attend without having contacted either the coordinator or the chair to indicate that they weren't going to be available. So in other words, they just aren't there, and nobody knows why. So that's the quote-unquote unexcused absence. How to address circumstances where you have a board member that does make contact, but simply they are so often unable to attend that effectively they're not serving the purpose of a board member because they're so often absent. That's the second scenario you have to think about. And then third, administratively, at what point should it be a full board vote versus an administrative act? For instance, we had a board member today that is traveling, had international flight, was unable to attend. That's certainly something that could be contemplated as a basis for an excused absence from the board. Does the board want that to each time be brought for the entire board? Is that something that the chair should be handling in an administrative function as the chair? And how do you feel generally about basically monitoring yourselves as a body?
Comments?
I just have a question. Was that put in, the 2 consecutive meetings, was that put in based on the contemplation that we were only meeting quarterly versus monthly?
No, basically, that's just standard language that I've taken
Okay.
from another board in the city.
Okay, thanks.
Yes, Reverend?
I believe that our chairperson has the knowledge and the wherewithal to be able to wisely discern whether the individual has a valid excuse or is neglecting their duty. And then if she feels that is worthy to bring before the board, I think that that's the way that it should be handled. And when she brings it before the board, we can deal with it.
I agree with the Reverend.
Others?
Oh, I like that. All right. If it gets to the point where the chair has brought the concern to the board, so let's assume that now we've adopted it, and I'll rewrite this so that will reflect that. And it's now, the chair has said, we have an individual who has, let's give the worst-case scenario. They've literally fallen off the face, and we haven't been communicative, they're not responding. The worst-case scenario, they're not here, they're not participating. At that point in time, it is required by the statute that it be a 2/3 recommendation of the board going to the mayor's office that that person be removed. Are you comfortable with the rest of the language for how procedurally that would happen? Basically, the chair would then bring that to the board and there'd be a 2/3 vote. Is that what we're thinking is the way to do that?
The only word I have here is it's the 2/3 vote of the members present at the meeting.
Yeah, and that goes back to the first question,
Yeah,
right?
so-
Yeah.
I think this should be similar to, the 2/3 vote of the membership, whatever process, just because we're voting on removal in this particular instance. Yeah.
I agree with that.
Anybody disagree with that? Okay. So administrative function of the chair then brings it to the board, 2/3 votes of the membership, not of the people present at the meeting. And then it follows from there, the statutory process, sorry. So the 3 months, and this is something that Board Member Strickland had brought up as well. So the statute requires that, that a board member, as we discussed, take all this training in before they begin administering their duties, before they assume their duties and start being able to be a full-fledged voting member of the board. The 3 months here actually is my specific recommendation, and it doesn't matter if it's 3 months or not 3 months, but the concern that I have is you could have a person who's appointed to the board and who receives their appointment and who comes to their board meetings and never does the training. So they're holding a seat, but they're not able to vote. At some point in time, is it too long for that person to be in that state of flux. And that's so, again, the 3 months is just my suggestion. It doesn't have to be 3 months. It could be longer for all the reasons that were stated. But if you don't have something in the bylaws dealing with the situation, you could have an appointed member who can't vote because they simply haven't done the training.
Would that be, when someone is applying an interview, that's all would, come out in the interview of what the expectation would be, correct?
They would be told that during the interview process would be my presumption, not to speak for the mayor's office and the council, but I would presume, and it's certainly within the statute, if they were to review, that it's there and it will be on the website.
I agree that there should be some sort of timeline in place. I don't think 3 months is necessarily long enough, but I think there's a difference between maybe somebody beginning the program, completing the program, but without having a sense of how many hours the comprehensive training program is, it's hard to make a determination of that. And so that's my only concern, is that it's a pretty steep penalty without us knowing how long the comprehensive training is going to take. But generally, I agree that there should be some sort of timeline.
Would we be able to amend that further?
Sure.
Such as we're all going to go take the trainings. So if we put 3 months and we say, well, really, it needs to be 6, we have the ability to amend that going forward?
Yes, as a bylaw, it would be subject to amendment pursuant to all the amendment rules for bylaws, yes.
Well, I would say that we can already see that it's going to take more than 3 months if we include the topics that we've already covered. To me, you shouldn't be a board member unless you've been fully briefed on the public record laws, et cetera. So maybe we wouldn't have had that 1/2 session on the FOP, contract. But I'm just looking as I have had conversation about what's next in terms of the training. To get all of this done will take more than 3 months.
Yeah. So is there a recommendation for what should be in here? Because again, this is the timeline for when we've determined that basically they're not doing it, rather than, you see what I'm saying?
What do you think, Kyle?
I'm sorry?
I would say something along the lines, well, I think I would say 6 months here, but I would also say something along the lines of perceived to, a little less than deemed to have vacated, but if the chair and the board kind of makes that.
Yeah, the reason I wrote that language in this place and no other place is because it's a statutory requirement that they did the training. That everything else is kind of, you have a right to vote and you can make that determination, whereas if they haven't been trained, they've essentially vacated their seat by inaction.
Now, I have a question because I want to make sure I get some clarity on this. Are you saying that they have been unwilling to take the training?
I think it could be a combination of things. It could be individuals who just say, I'm simply not doing it, or individuals who simply won't make the time for it, or, because the real problem is not whether or not they're well-intended. The problem is that during the entire period of time that they're not doing it, they can't serve.
Okay, because the reason why I say it, Kyle, because that goes kind of different than what you're saying. The person has been trying to take the training, but it's taken longer than 3 months. But if the person is just not desiring to take the training, then that's something different.
I will share with you that, and again, the Safety Advisory Commission was different than the board. But I can't even remember the number anymore of how many commissioners there were. I think it was 17, but I'm like, 17? And there were members who refused to participate in certain activities or training. And then there were, and again, these weren't large numbers, 1 or 2. They just weren't there, for, to me, a significant number of meetings. I would certainly hope, but it's a hope, that we would not have that situation. We will have to address it if we do, but I do think that the time period, if we can do this, of 6 months is more appropriate than 3.
I would, Chair, if I could, I would like to go back and say this. I believe that that should be part of the interview process as well for a person having a desire to be on this board. I think this should be explained to them. This is what's going to be required of you, and you must be willing to do this. You know, and I think that we could alleviate a lot of that problem right there, because if they agreed to do that, then they agreed to do that.
And what we're doing today and in the months coming forward will provide the kind of background and relevant information to those who are involved in the interviewing process, because it's still the same process in terms of, it's the mayor's, office, but they will have learned, from this, and absolutely can ask the questions and show. So, excellent point.
I agree generally, and I think the one thing I will say is making this determination without having the hours requirement figured out is slightly I think it's a little problematic because, how long is your training on implicit bias going to be versus, let's say if you're talking about a ride-along,
Right.
that would be a full shift versus, a number of these different aspects to it. So that's my only worry is if, let's say, somebody completes 4 out of the 5, or you can combine some of these trainings. But that's my only concern is that just without having an hour requirement set out, it makes it difficult to determine how long each of these things might take.
Before our October meeting, because, again, I'm the person who's been charged with setting the agenda, but I do it in conjunction, of course, with the city attorney's office, provides a lot of the trainings, deputy director speaks, the city. And I've pretty much been just going from one meeting to the next, trying to the tone, the capacity to cover certain materials in, 3 hours. But I will do my best, working with, again, those individuals before the October meeting, to take what's set forth and try to plan it out. Okay?
I think that 6 months is a good amount of time. We've all made a commitment that we're going to do this. So I think 6 months, and I don't think that the training is going to be that overwhelming and overpowering, and I think all of us have made that commitment to do this.
Okay.
So 3 might not be enough, but 6, absolutely, we can, I think we're all so committed enough that we'll do it.
We're all thinking 6, is that what I'm hearing?
Yes, let's go with 6.
Crossed it out and put in 6, okay. Moving on to Article 3. Any other questions or comments on Article 2 before I flip the page?
And Laura, I'm going to give you a hard stop for 4:45.
Okay.
Which means we will probably, I'm going to change the October agenda. We would complete the review of the bylaws in October. I'll change the subject matter of what I already had there, but I do want to give us enough time today to talk about some specifics around training in October. Again, the length of the meetings, I thought that we had voted, but the minutes didn't reflect this, that we had agreed that our future meetings would be 3 hours. I think we need to go back and clarify that because that's not what the minutes reflected. It was only for this meeting, and just a few other things like that.
Okay. In Article 3, Organization and Officers, I can make this one actually pretty easy. Sections 1, 2, and 3 are actually derived directly from the statute, and that's the creation of the fact that there are 2 officers, the chairperson and the vice chairperson, and what those roles will be. These can be expanded if you feel appropriate. Their officers could be created as the board determines or that might be necessary. But in terms of what I've actually provided in the bylaws, these are just directly taken from the statute. Any issues or questions or concerns with sections 1, 2, and 3?
And I will share with the board that it is my hope, and this is the process that I hope to use, that I will identify someone to serve as the vice chair and will bring the name of that person to the board at the October meeting. It is also just my thought as we get further into this, that we will have committees. As an example, and I don't know what it would be called, we have a responsibility, and actually it kind of goes back to maybe what the mayor was saying, this thing of bringing trust between community, and police. How do we go about doing that? Our community involvement. Certainly, I would want us to have a general discussion at a board meeting, but I would then task a specific committee to come up with specific recommendations. Again, just sharing with you so you'll understand how I plan on operating.
Which is an excellent segue to section 4. Committees and subcommittees. The chairperson may establish one or more committees, each of which will consist of 3 or more board members. This paragraph also comes from the statute. I'm sorry, the first sentence does. The rest of it is not. The rest of it is suggested. So the question that is to the board is, I have it structured so that the chairperson appoints the committee members, including the chair, and that the chairperson indicates the need for a committee. This is just general board and commission work. It's usually the chair who is administratively responsible for the work of the board, and so they tend to be the individual that creates committees and creates committee assignments, including chair and who's going to be a member. What is sometimes different across boards or commissions is whether or not those committees become codified in some way or be part of the bylaws, and whether or not they become standing committees. And what I have seen is some boards have the determination as to whether or not it's going to be a standing committee, be a board vote, and some have that be still a chair vote. And then some committees don't differentiate. Some chairs, some commissions don't differentiate. It's just committees, and others do distinctively differentiate between a standing committee and a special committee. If you want to differentiate, what's the difference? Standing, of course, is there until the board as a whole decides it's no longer relevant and you want to disband it or dissolve it. Special committees are appointed specifically for an intended purpose. For instance, setting up the training hours and making a determination might be a special committee, or you might decide, no, we actually need a standing committee on training, and then having 3 people who are part of that standing committee then be responsible for bringing forth the specific training required for board members. So those are the examples. So I just needed to hear if there's any feedback on what role the board as a whole might play in committee work, or if it should all just be with the chair.
I think what's written out here is some combination of it, but a lot of discretion handed to the chair, I think makes sense.
Any other thoughts?
I agree with that.
You agree? Agree?
Yeah.
All right, see? All right. Moving right along then. Article 4. Am I hard stop yet? Not yet. All right, I got 6 minutes. Article 4, duties of members and standards of conduct. So you'll see that removal of members ties into what's going on here with absenteeism. So as again, we've already had that discussion. I will make sure that section 2 reflects your general thoughts and about absenteeism and how that might be brought to the board as potential removal versus just dealt with on an administrative basis. Mostly in section 2, I do have it as the administrative aspect of this. If you have any thoughts or concerns in light of that prior conversation, please let me know. Section 1, Rob had an edit for me that I haven't put in here yet. This says the board is a public body. As a public body, board members are required to attend in person in order to be considered present for purposes of constituting a quorum and to vote. That is true, and that's required by statute, which says we're going to follow the open meetings laws for the state of Ohio. But what I do need to add in there, and I will add in there, is that in the event, I'm just thinking about COVID again, in the event that either an emergency declaration or a change in code occurs that would allow for public bodies to meet virtually again by necessity of some sort, I want to make sure that you have some wiggle room in this bylaw so that you don't have the law change and then you're stuck with your bylaw saying you still have to be here in person. So if everybody's okay with that, that was an omission on my part and I need to add. Good? Okay. Confidentiality. So section number 3, this is a basic confidentiality disclosure language. It comes from the acknowledgement of the fact that once you start actually hearing investigations, you may well be hearing things that are confidential in nature. Some of them are confidential simply because they are also part and parcel of a criminal investigation. But some of them are confidential because there's actually a statutory requirement of confidentiality. And what I'm thinking about is if you get a record from BCI or from LEADS, which are the automated databases that provide criminal background information, if that information is able to be shared with you, and that would probably happen during an executive session, then there would actually be a statutory requirement the board members not share the information that they learn. And so I wanted to make sure that there was a provision of your bylaws generally addressing confidentiality requirements. You might, so take a look at that. If there are any questions or concerns, this is pretty standard language across a couple of other boards and commissions that have similar confidentiality concerns, but that's why it's there. Conflict of interest. So conflict of interest and professionalism, and this is probably a good place to end, Janet, once we get to this.
Okay.
Conflict of interest basically is just a reflection of the conflict of interest forms I believe you've already signed as becoming part of a board member. This is just to make sure that that's encased in your bylaws as well. But Section 5, professionalism, some of the conversations we've been having here today about exposure to things outside of the mandatory training and seminars and updates and things like that could also fall, if you chose, into the professionalism section, because the statute not only requires that the board develop a comprehensive training program, the statute also requires that the board will develop standards of professional conduct. And so if there are things that you feel are part of being fully educated in the area, so that it's not a training per se, but it's more about the kinds of things you would learn at a seminar, that could also be professionalism and a professionalism standard of conduct. So it could be about your demeanor, it could be about ethics, it could be about your attention to the work that you're doing, it could be about education, could also fall in this bucket. And so this right here is just a placeholder for those ideas, and that's something that the board's going to have to also embark upon, setting about these standards of professional conduct in order to meet the statutory requirement. So I'm interested in any feedback you might have on that, but that might be a broader question. For now, it might suffice to just have a placeholder here. I don't know if it would be appropriate to come up with standards through a committee. I don't know, that's up to the chair. But I do know that's something that does need to be addressed to meet the statutory requirement, and this would be the place where it would go.
Thoughts from the board on this topic?
Yes. Sure.
Yes.
See, oh, yeah, I do think it might be helpful to have a subcommittee draft standards. It touches on concern that I raised last time about, appearing to be impartial and promoting public confidence in the work of the board, so that, having some language that really fleshed out what we mean by professionalism, and it does, that would be a place to address the concern that I have about the mission of the board.
Anyone else? Yes.
I'll just say in my work with the area commissions and their bylaws, a lot of them now are drafting language related to professionalism and standards of conduct. Unfortunately, because they have members who they want to try to remove and the bylaws don't speak to that. And a lot of them have just crafted very straightforward and simple statements talking about basic levels of decorum, respect, civility, integrity, things of that nature. So you get to decide whether you want it to be paragraphs and paragraphs long, or whether you want it to be some short, succinct statement that just has very plain meaning.
It's my thinking as I sit here today that I would appoint a committee. I am not, as your chair, prepared to do that today, so I don't know what that does in terms of the timing of trying to I
You
was
have 2
hoping that
years.
to be able to get the bylaws approved at the October meeting, but if this needs to be completed before we can vote,
I don't think that would be the case. I think that by leaving the placeholder here, you can amend the bylaws to add the standards, because the initial board is required to come up with them, but the initial board is at least the first 2 years of this board.
okay. Then I'm trying to keep a running list of my task, and maybe Colleen's minutes will do that. So I will give again this, so just let's leave the language the way it is, and then your chair will think about, a committee and who would be assigned to that committee, and would share that at the October meeting. Okay?
Excellent, and I will say, Janet, although there are a number of articles left, when I'm looking at them, and I'm not saying we can do them in the next 15 minutes, but Article 6 dealing with legal counsel, Article 8 dealing with adoption, certification, and publication of rules and regs, both of those sections are largely statutorily determined. So the only real meat left in the bylaws in terms of having conversations are, to the extent that there are any changes to the administrative coordinator position and inspector general, that could be a conversation. And then Article 7, regular meetings, procedural rules, quorum, order of business. That's,
Well, we'll have you on the October board meeting, and thank you so much for it today. So,
you have a question?
I'm sorry.
Jackson, I would like to recommend, in order for us to really expedite this when we meet the next time, that we all read through this and be familiar with the remainder of this document. And any questions that we have, jot them down and have them ready when we come back in here so that we can kind of expedite things.
Well, I would hope, and again, it's a hope, that board members are reviewing and reading all of their materials before they come to a meeting, knowing that we're going to have a discussion of them. But certainly in terms of this, and anything else that you may have thought of connected to board meetings. So for the there were challenges around scheduling a full day at the academy, where we would have covered the ABCs of policing plus scenario. So I've made a decision. I know it's challenging to take a complete day, a volunteer when you have work to do. So I came up with a compromise. At our next meeting, and I'm changing it because we're not finishing everything today, we would finish up the bylaws, we would get a report back on our social media policy, and we would cover the ABCs of policing. So rather than having to go to the academy for a staff to address us there, they simply would be a part of this meeting. Contemplated on an hour and a half. George, we may now have a little bit more time. What I'll need to move would have been a presentation by Jeff Furby, an assistant city attorney, on the substantive legal training. And so we'll move that into probably November. It would have been my preference if we all could have gone to the academy for the scenario training, because one of the parts that I found rich about that was the conversation that we had amongst ourselves, which would be a public meeting, I understand that, about that day and that time. That still may not be possible. Deputy Director Speaks shared to me that he has made these arrangements, and so Colleen will need to do a poll. So for every Friday in the month of October, both morning and afternoon, that could take place. My goal is that we be polled to see if there's at least one of those 4 Fridays when we could all be there. If we can't, then what we'll need to do is to break us up into at least 3 groups. Again, I would not put the burden on the academy to train like 2 people at a time. So we would divide up into 3 groups, and we would have to choose one of those time slots. Is that acceptable to the board? And again, I really hope that, and I haven't even looked at those Fridays, but that somehow, I mean, I just know off the top of my head that there's one when I'm not available. So the more practical thing might be the breaking up into groups, but let's see what happens. And then if we do that, then probably the next best option would be at the November board meeting. We could just put it on the agenda for a conversation amongst us about your experiences. Kyle?
Yeah, no, I think that makes sense in terms of especially having somebody come in and present. The only thing that I would flag is because with COVID and Delta, not knowing what things are going to look like down the road, it's going to be it might be hard to plan some of those later trainings. But generally, I think that sounds like a reasonable next step.
Okay.
I'd like to say, I think it's imperative that we try to get to the academy or wherever we do it, it doesn't matter, but that we know what officers are, what their procedures are and the constitutional law aspect and what they go through. I just think that's so
All of that
important.
comes in. The scenario training is definitely at the academy.
Okay.
I mean, no, you can't do that here, or
Right.
it has to be. It has to be at the academy, believe me. Brooke would say yes to that, without a doubt. It has to be at the academy. But a lot of the other topics that you just mentioned, they're woven in. Okay. Any other questions?
One thing I'd like to interject, Kyle, in reference to this time frame stuff. I think with each one of these that we go through, we can keep our own time on how much time it takes for us to go through it, and then compartmentalize all that time together on each of these, and then we'll be the barometer as to how much time it takes for each one of those trainings.
Well, the trainings that we're talking about primarily, at this point, when you're talking about time, would, except for the scenario training at the academy, and again, we're talking an hour and a half or 2 hours, but it's my plan that the training would occur during our meetings. And right now, we have set meetings once a month, second Tuesday of the month. And I do need to clarify this, and I don't think this needs to be a motion, just by show of hands. Can we go from 2 to 5? Would I promise a 15-minute break? Yes? Okay, yes. Yes.
I serve on another board that also happens to meet the first Tuesday of each month. And it's right down the street. It's a health center, but they start at 5. So I personally would appreciate a 5-minute window if I could. If we meet till 4:45 or 4:50, or if I could leave 5 minutes early, because when we first set these meetings, it was 2 to 4. There was no, that time crunch wasn't there for me.
Let's try, and again, work with the group. I'll try the 4:45.
Okay.
But if you need to excuse yourself, it's an excuse.
Yes, thank you.
for
I just
all of
don't
5
want it to
minutes.
seem like, why
Okay.
does she leave
No,
5
no,
minutes?
no, and
It's just because
that's
another
great.
conflict.
I am one who keeps notes just everywhere. I think that I have covered everything that I needed to share with you today. I'm looking around. I think that's everything. Again, please think about the Inspector General and this conversation you're going to have with Mr. Berg. I'd ask you to, in terms of your priorities, that you do that now. Don't wait until he calls. Give it some thought. I don't know how the scheduling of those calls are actually, I'm assuming he's just going to reach out to individuals?
I believe his administrative assistant is going to be reaching out to get the call scheduled.
Okay, all right. But if you could give it, some thought, be a great time to do it in light of our conversations, here to date. Any other comments from any board member? No? Then you will notice that we've put it on the agenda. I now need a motion to adjourn from one of the board members. So moved. I would say moved and seconded. Moved by Brooke Burns, seconded by Reverend Charles Tatum. All those in favor, raise your hand. We are adjourned. Do you have something for me?